Greetings. My name is Mark Bach. I'm a U.S. patent attorney. I'm going to present a method of creating a patent portfolio that can be very useful in many different ways. My patent practice began back in the last century as a patent agent and then patent attorney in a number of law firms in downtown Chicago. And then in 1993, I joined Abbott Laboratories as an in-house patent attorney. In 2000, I joined Snap-on Tools as their sole in-house IP attorney. And then in 2008, I joined Navistar as senior counsel and vice president of International Truck Intellectual Property Company. Over the centuries, I've seen patents used in a number of different ways: offensively, defensively, licensing, securing financing for a patent owner. All these different ways of using a patent require a patent portfolio that has a number of members that are of consistent high quality. And that is exactly what I'm going to be discussing now, is how to create that type of patent portfolio. This is from a US perspective. A number of other standards for creating patents can be generated based on other different sets of laws from different jurisdictions. But I'm going to focus on what I know of the US patent system. All of this creation of the patent portfolio based itself on implementing and enforcing a written standard of exactly what you want each patent to be. When it comes to a patent, key thing is to try to tell a story. Our species loves stories, and we want to have the patent itself to be a story. Essentially, but how the invention was conceived, or maybe the problem that existed and how it was solved. But all this is always keeping in mind potential licensing opportunities, not only in your client's key area of commercial interest, but also in other competing areas. Things are more palatable to be licensed in those areas. The specification, you want to include language that anticipates many different applications of the underlying technology. That creates a lot of value. When it comes to the patent application itself, when you're starting to draft it, you want to keep the title very succinct and in caps, no longer than 6 words. Why? Well, that is based on a lot of the electronic filing systems on a number of different patent offices, including the PCT, the WIPO patent office, and their electronic filing system. Your background should be very, very brief, no more than 2 pages in length, written for a sophomore in high school. Why that? Because when you enforce a patent, somebody's going to pick it up and read, well, at most, the first 2 pages. So you want that written in a very basic level. You don't want to mention any disadvantages of prior art, because that can only hurt you. And then you don't want to use any of these words: preferred, best, must, invention, optimal, essential, critical, required, necessary, important, advantageous, beneficial, prior art, or desirable, or any variant of those words. Why? This list was created by reviewing a number of different decisions of the US Patent Office and the Court of Appeals of the Federal Circuit in the United States, where different patents were shot down or narrowed in the scope because of the use of these words. Of course, superlatives never used in patents. Why? Well, because it's a superlative. you cannot achieve that. When you're drafting the application, you don't want to include any objects of the invention. Why? Well, because the scope of the claim is going to be limited to what those objects are. The summary, you want to include something that mirrors the independent claim in prose form. Why? Well, that way you're not going to be able to limit the patent, limit the claims of the patent by what's in the summary, because they're the same, different language forms. You want to broaden the specification, include multiple embodiments and alternatives to those embodiments. And you want to describe methods, not limited only to methods of operation, but methods of use, methods of construction, every type of potential application of the invention you want to include in the patent application. And when it comes to the claims, you want to prepare multiple patent applications. That means multiple claim sets, apparatus, methods, each set of claims in a different claim set, and each of those different claim sets filed in different patent applications. You want to make sure that every potentially patentable item that's disclosed in the spec is in the claims. If you don't, then you risk dedicating that concept to the public. And that dedication could end up being very broad, and you don't want to have to fight over exactly what was dedicated to the public and what was not. But you want every word of the claims, every word you use in the claim, you want each of those words in the spec used in exactly the same manner as it is in the claim. If you say A is connected to B and C and D, your spec must say A connected to A, B, and C. And it's very easy to try to avoid any type of the old traditional patent languages like, oh, said element. No, nobody says said. Some patent attorneys did that a long time ago. We use the. That's what everybody else uses. And with the claims, you want to use common everyday terms. And every claim literally present, word for word, in the specification. That way, you are certain to have support in the specification for your claims. Abstract, no longer than 150 words. And why? Well, again, a lot of the electronic filing standards that are set up by different patent offices have that limitation. So better to comply with that. And it's easy to use the broadest independent claim and put it in prose form and stick that in as your abstract. That way you don't have any differences between summary, claims, abstract. One is not going to limit the other because they're all the same. And if you wind up with a patent examiner that decides, well, you need to have more elements in the abstract, won't allow the claim without that, okay, fine. Play his game and make sure you put in the response that you file, say, you know, all these words that are added in this amendment into the abstract are only done in order to meet the requirements of this particular examiner. That way, you don't have to worry about everything that you imported into the abstract being used to limit the scope of the claims. And then when you finally get everything put together, you're ready to file. And we talked about having different patent applications for different claim sets. But you want to file all of them on the same day because you don't want one cited as prior art, I guess another one, because all the same. All the same technology, all the same idea. By the same, I mean same background, same drawings, same specification in all of them. But they differ in the title, the summary, key thing, the claims, and the abstract. Summary and claims, summary and abstract differ because the claims differ. And as we pointed out earlier, yeah, summary and abstract come directly from the claims. We follow all these, and then we wait for the patent office to act on the examination. When you come to foreign filing, you want to consult your foreign counsel. Make them known, yes, we have 5 different patent applications, but they're all the same thing. They only differ with different claims, the summary, the abstract, and the title. That's it. There are different standards used by different patent offices and different examiners. US, they would give you a restriction requirement. And that's why we have different patent applications for different claim sets. In other countries, that may not be the case, in which case you could bundle all of them together in one patent application. In that case, go ahead and do that if foreign counsel says, yes, that's true, and thereby save all of your filing costs. If you have any questions at any time, please feel free to contact me, send me an email. I look forward to discussing anything with you at any time. Have a wonderful 2021. Peace be with you. Bye-bye.